All right. Welcome to our second critical conversation for the year 2025. We are pleased to have you join us for this important dialogue as we continue to explore critical issues at the intersection of law, climate change, climate litigation, climate justice, and of course, sustainability. So before we get started, I will just mention a few housekeeping rules. If everyone could kindly switch off their cameras during the session and remain muted unless invited to speak during the Q&A session. You should also utilize the raise hand feature or the chat function to pose questions. And lastly, by joining the session, you consent to the recording of the event. So I will just do a brief rundown of the program. So to start off, we'll have our chairholder, Prof. Oliver Fuo, give us some welcome remarks and briefly tell us more about CLES and the Critical Conversation series. I will then introduce the guest speakers. After that, our first speaker, Dr. Wendy Muzangaza, will start the first presentation. And then our other guest speaker, Ms. Tatenda Muponde, will also get into her presentation. After that, we will have our Q&A, which will be facilitated by Ms. Innocentia Maslangu, who is one of our LLM researchers. After that, we will then have final inputs from the speakers, and Ms. Ledile Sekwakwa will then wrap up the event for us. So without wasting much time, I will invite Prof. Oliver Fuo to come and give us the welcome remarks. Thank you.
Thanks very much, Nesia. Good afternoon, ladies and gentlemen. Thanks for joining our second CLES Critical Conversation series for 2025. We are very happy that you're able to take time off your very busy schedules to join us. We appreciate your presence and we look forward to engaging with you. For those of you who are joining us for the first time, I will briefly introduce CLES and tell you a bit about our Critical Conversation series. For those of you who attended our events before, apologies for boring you with the routine background story, which we usually run. The South African Research Chair in Cities, Law and Environmental Sustainability is a research chair which is housed by the Faculty of Law of the Northwest University in Potchefstroom. It was established in 2018 and has been in operation since then. It started as a Tier 2 chair, and this year was upgraded to Tier 1 chair. And it is funded by the National Research Foundation of South Africa and forms part of the National Research Foundation's Research Chair Initiatives. It is an academic institution that is devoted to legal scholarship and the development of especially research skills that are partly needed to enhance urban development in South Africa and beyond South Africa, in Africa and also other parts of the globe. To this end, we host a number of postgraduate students that are drawn from South Africa and other African countries. And we also have postdoctoral research fellows. All of them conduct their research in the area of law in intersection with urban governance, urban development, and environmental sustainability. As Nesia indicated, I was appointed as the chair by the National Research Foundation in May 2025, and that is expected to run until 2029. It is our aim to produce and publish relevant research of an excellent academic standard through postgraduate dissertations and theses, as well as through journal articles, book chapters, books, reports, and policy papers. We also intend and we've been doing that, to actively participate in science engagement with policymakers, government officials, NGOs, and any other institutions that are devoted to urban development and sustainable governance, with the intention of ensuring that our impact is felt, especially at the national level. The CLES Critical Conversation series was launched in 2019, and after that, we had a number of them which took place at the Faculty of Law here in Porch. And after COVID, we decided to move it from the moot court room in Porch's room to the online Teams platform. And we decided to keep it in that manner because we think that we can be able to reach out to a wider audience. But usually, the Critical Conversation series is an opportunity for us to invite experts in any theme or topic that falls within the broader range of work we do, to be able to engage with the wider scientific audience. And through this, we are able to have fruitful engagements on any topic which is under discussion. Today's Critical Conversation deals with a theme between rights and realities, climate change litigation as a tool for transformative environmental justice in South Africa. And our speakers are Ms. Tatenda Muponde and Dr. Wendy Muzangaza, who will be introduced shortly by Nesia. I want to thank Wendy and Tatenda for agreeing to be in the spotlight today, to deliver today's lecture and generate the discussion which will follow. And I also want to thank Nesia and the organizing team for bringing all of us together to be able to engage in this level. As she indicated in her introduction, we have a formal program to guide our discussion. That you should feel free to engage after the presentation. It is not really a very formal event. We intend to make it as informal as possible so that you can be able to all equally contribute towards the discussion. Thanks very much, everyone. I'm looking forward to the presentation and the discussions that will follow. Back to you, Nesia.
Thank you, Prof, for the welcome remarks and, of course, for telling our participants more about CLES. Okay, so please join me in welcoming our two esteemed guest speakers for today's critical conversation. We will be presenting on the topic Between Rights and Realities, Climate Litigation as a Tool for Transformative Environmental Justice in South Africa. Starting with our guest, Ms. Tatenda Muponde. She is an environmental lawyer at the Center for Environmental Rights, a nonprofit organization and law clinic based in Cape Town. As part of a team of activist lawyers, she is dedicated to defending the environmental rights of communities with a strong focus on climate litigation. She currently serves as an attorney in the CER's Activist Support and Training Program. Tatenda holds both an LLB and an LLM in Environmental Law, cum laude, from the University of the Witwatersrand, and is currently pursuing her PhD at the University of Cape Town. In addition to her legal work, she is the founder of I Root for Nature, a digital media platform aimed at raising awareness on environmental law, sustainability, and climate justice. In recognition of her advocacy and leadership, Tatenda was named one of the Mail and Guardian's 200 Young South Africans in 2003. Our second speaker, Dr. Wendy Muzangaza, is a postdoctoral research fellow at CLES at the Northwest University. She holds an LLD and an LLM in Environmental Law and Governance from NWU and an LLB from the University of the Witwatersrand. Her research focuses on climate change, environmental human rights, and climate change litigation in African contexts, with a particular focus on city-level climate change governance and how litigation can support climate justice, empower communities, and foster resilient cities. Dr. Muzangaza has published in internationally accredited journals and is contributing to book chapters on climate governance in African cities. She has presented her work at various local and international forums and has been part of global delegations on business and human rights in the Netherlands and diplomacy and international relations in China. She also serves as a co-editor of the Potchefstroom Electronic Law Journal and leads the CLES Talk podcast, which promotes scholarly dialogue on cities, law, and environmental sustainability. We are honored to welcome these distinguished speakers whose work offers critical insights into climate litigation. To begin our conversation, please join me in welcoming Dr. Muzangaza to share her presentation. Dr. Muzangaza, you can come to the floor and share your presentation.
Anisha, if I may, I saw Wendy was online, but then she was offline. So maybe she has some connectivity issues. If that's the case, perhaps we can just ask the second speaker to do the first presentation, if that would be possible.
All right. Wendy's presentation was supposed to be an introduction of some sort. So let me just, okay, if she's offline, maybe we can invite Ms. Tatenda Muponde to just come through.
Sorry for the interruption. She joined
Yes.
again now with a different profile, so I think she'll be good to go.
All right.
Hi, Nisha.
Hi, Dr. Wendy.
I'm so sorry about that. I'm experiencing network problems. Could it be fine if you please share my slides, and then I can just speak because I'm really experiencing challenges on my part.
Okay, I am sharing the slides now.
Thank you.
Okay. Can you see the slides?
No, I can't.
Okay. They should be up shortly.
Okay, now I can see them.
All right, take it away, Dr. Wendy. The floor is yours.
Thank you so much, Nessia. Good afternoon, everyone. My sincere apologies for the network problems. We don't have electricity over the side in Zoom, but I will try to go through this as fast as I can before the internet gets more worse. Anyways, thank you, Nessia, for the welcome. My name is Wendy Muzangaza, and I'm going to be giving an introductory talk to this critical conversation that we're having today. So basically, I'm going to be introducing climate change litigation, just a brush on environmental human rights and their relevance or their role in climate litigation and for transformative environmental justice, with insights from African jurisdictions, mostly Kenya, South Africa, and at Uganda, where there have been cases, climate litigation cases so far from Africa. And then I'm also going to touch a bit on just the general limitations and challenges of climate litigation. You can move to the next slide, Nessie. So, climate, I think it is now quite common knowledge that we are experiencing the climate crisis, and it is unprecedented. We are experiencing the climate crisis to a level that has never been experienced before, and this requires urgent redress and new ways of thinking or new ways of trying to solve the climate crisis. It has been said that we are in an age called the Anthropocene, which signifies how humans, us as humans, have contributed to the climate crisis, but also which signals that we need to change the ways in which we are addressing climate change because it's getting way out of hand. So, climate change is a human rights issue because it impacts on environmental human rights. And by environmental human rights, it is basically all of the human rights you can think of. We can talk about the substantive environmental right in terms of the South African Constitution. This would be a section 24. There are political environmental rights, which are your right to life, right to dignity, right to equality. Then there are socio-economic environmental rights, which are impacted by climate change. And this is your right to housing and water and health. And then we have procedural environmental rights, which are your access to justice and all the other rights. And then we also have the rights of nature, although in South Africa and in most African countries, these have not been recognized yet, but they are also part of environmental human rights. So just to quote John Knox, who was the UN Special Rapporteur, he did mention that the enjoyment of rights is dependent on a healthy environment. And a healthy environment also then constitute a climate which is healthy as well, and not the climate crisis that we're experiencing. So human rights generally play an important role in mediating the human environment and the human-human interface in the environment context. How do they do this? Human rights generally, they foster stronger environmental laws. They provide a safety net that closes the gaps in environmental laws. They provide non-derogable minimum standards for environmental governance. So this is basically saying they are your use-Coggins norms. If we are to talk about international law, where we're saying they are non-derogable, they are like at the top of the hierarchy of in the hierarchy of laws. So human rights also improve the implementation and enforcement of environmental laws. They promote environmental justice, which is a subject that we are going to be touching on today. Hello?
We can hear you, Dr. Wendy.
Oh, sorry. Okay, sorry. I thought it was too quiet. I didn't hear any response. All right, thank you. They also increase public involvement and foster government and private sector accountability. So these are the benefits of human rights generally, and also in the human environment context, which also touches then on climate change. So what has been happening recently, or maybe not recently as such, but what has been happening is there's been a lot of failures by governments to address climate change. And by this, I don't mean some governments are not trying at all. Of course, there are people or governments which might not be trying at all, but most of the issues that are being touched on when we go to litigation, it's to do with the measures or the responses that they are using to deal with climate change or to address climate change as inadequate. So these responses are inadequate. They do maybe just a little bit of what they're actually supposed to be doing to really address the problem, just to make face to say they're addressing climate change when maybe it is not enough. So in results, there has been a violation of human rights. And this, amongst other reasons, has also prompted people, petitioners, to go and approach the courts to try and address these issues. So which is what then brings about climate change litigation. So climate change litigation, though there is no specific definition, it is basically legal action that is used to address the causes or the consequences of climate change. It is an evolving field that uses the law to address climate harms. So it is one tool to address climate change. It is not the beat and end of climate change. It is just one tool that is and should be used in conjunction with other tools. So climate litigation has been instigated against governments and also against corporations like multinational corporations, for example, Shell, and other big companies that have contributed, let's say, to pollution and things like that. The purpose of climate change litigation is basically to accelerate government's efforts to implement emission reduction targets, to demonstrate the insufficiency of national goals, as I was mentioning just now, to hold emitters accountable for harm to vulnerable communities, which speaks greatly to environmental justice, to bring global climate change concerns to local action. This is basically saying climate change has mostly been viewed as in the abstract, as if it's something foreign. But climate change litigation, and especially in conjunction with human rights, they bring that problem to the ground, and we can relate to it more. Our governments should relate to it more because now it's being viewed locally. We can see it every day, and it's affecting our human rights and other aspects of our lives. And then it's also to enforce adaptation actions or to recover damages that can result from the failures to adapt, to drive policy and legal changes, to enforce environmental human rights, and to address the urgent need for climate action. So moving to the next slide, the trends in climate litigation, generally, globally speaking, and mostly in the global north, this is where climate change litigation is mostly pronounced. They started climate change litigation, I don't know, a while back before we did. And it's way more developed and they have more cases than we do this side in Africa. Although there's also been some arguments that, maybe we also do have some cases that also were climate change litigation cases back then, but according to the sources that we use to get data on climate change litigation, maybe those cases were not captured or were not classified as climate change litigation. Hence, there is now a move to open a southern route to climate change litigation, which specifically looks at climate change litigation from a global south perspective and not from the dominant global north perspective. So basically, there's been a global surge in climate litigation, especially post the Paris Agreement, where the link between environmental human rights and climate change was endorsed. And as I said, in Africa, we have a few cases to date. Although there's growing momentum of these cases, especially in South Africa, it's really leading in terms of that in comparison to the other African countries, as well as Kenya and Nigeria. But what we can see is from most of the cases here in Africa, most of our cases are rights-based. So it's rights-based climate litigation where we, in the side in Africa, we mostly rely on the Bill of Rights and on the Constitution to interpret during our cases. But in the global north, it's a wide variety of legal bases, including tort claims, negligence, and all the others. But in Africa, it's mostly rights-based. That is the trend that we are seeing currently, and they are increasing. These cases are increasing. So it is a good thing for us. So as I've said, we are mostly experiencing rights-based climate change litigation in Africa. Sorry, Nessie, I cannot see your slides, so please just move to the next that says role of environmental human rights in climate litigation based on African perspectives. Yes, so if we do look then at what the role of human rights has been in climate change litigation and using examples from Africa, we can see that environmental human rights have been instrumental in liberalizing locus standi, which is legal standing. Environmental human rights, they often broaden who can bring a case. And in many African jurisdictions, the courts interpret constitutional or statutory environmental rights liberally, which then allows for public interest litigation. For example, in the fuel retailers case, it just shows us how South African courts adopted a flexible approach, which affirmed that environmental concerns justify expanded standing for NGOs and community groups. So all this was possible because of a human rights interpretation. They also have been instrumental in strengthening environmental governance. So environmental human rights, they impose positive obligations on state. They tell the state you have to do this, and that to regulate and protect the environment. So this then enhances state accountability. For example, in the Serak case in Nigeria, the Nigerian government was found liable for failing to prevent environmental degradation, and they say that the failure of the government to regulate third parties, which was in this case Shell, violated socio-economic and environmental rights under the African Charter. They've been instrumental in clarifying non-state actor duties. So even though human rights obligations traditionally bind states, the courts have started to assert that corporations and these big companies may also bear responsibility for environmental harm where rights are at risk. So normally, when you are pursuing climate litigation, maybe under another legal basis, it could be difficult because they might bring in issues of causation and all that, which might be difficult and has been difficult in bringing non-state actors to accountability when they have harmed the environment or where they've been responsible for climate change. But when you're using human rights, it makes it easier to go because you don't have to prove causation. You just have to prove that you just have to show that the rights of, let's say, a particular community have been affected. Let's say the right to water, for example. You might say that the water has been polluted by a specific company, and then you can actually approach the courts in that. So environmental human rights have also been useful in expanding EIAs, the scope of EIAs. So environmental human rights would require that EIAs consider climate risks and human rights. For example, in the Save Lamu case in Kenya, the Kenyan court quashed the EIA license for a coal plant due to the project's failure to consider environmental justice, community participation, and long-term climate impacts, which were anchored in constitutional rights. They've also been instrumental in enhancing access to remedies. So as I said, with human rights, you are not only then focused on the remedies that may be available, let's say, in environmental law generally, but also any remedies that could also be used in terms of human rights law. For example, in the Deadly Air case, which is in South Africa, the court recognized that the government's failure to implement air quality plans violated constitutional rights to health and a clean environment, and it affirmed the justiciability of environmental rights. Then they've also been useful in mobilizing procedural rights, which is your access to information, right to participation, right to be informed, right to legal remedies. And these were emphasized in the Save Lamu case in Kenya, as well as the Tabametsi case in South Africa, where the courts insisted on meaningful consultation and rigorous assessment, as well as advancing transformative constitutionalism. So generally in interpreting environmental rights in Africa, generally speaking, as well as in rights-based climate change litigation, the courts must prioritize sustainable development strategies that balance economic growth with environmental conservation. So basically, what this paragraph is aiming at is, yes, we do have climate litigation generally, but our climate litigation in Africa should be sensitive and consider our own peculiarities in Africa. For example, that need to balance economic growth with environmental conservation, as well as to address the inequalities in access to resources and exposure to environmental hazards. So, for example, the legacy that apartheid, for example, left, it left most Black communities in spaces where some are exposed to environmental hazards or easily exposed to climate, to the negative impacts of climate change because of where they stay, for example. So when we are interpreting environmental human rights, generally, as well as in climate change litigation, this type of litigation should also be sensitive to these issues. So it could be, for example, victims of environmental disasters and of pollution, as I just said, and just as that case in Nigeria that is cited there. So how then can climate change litigation contribute to transformative environmental justice? I think it's basically also similar to what I was just talking about when I was talking about the benefits of using environmental human rights in climate change litigation. So climate litigation could contribute to transformative environmental justice by holding actors accountable. It does climate litigation does provide a legal avenue to challenge the actions as well as the inactions of governments and corporations which contribute to climate change and their impacts. So this could result in forcing these actors to reduce emissions or to implement more ambitious climate policies or to compensate victims for the harms that may be caused by climate change. So, for example, there are cases that target the carbon majors for their historical emissions and those that challenge greenwashing tactics. So by greenwashing, it's basically a company saying, for example, appearing as if they are being environmentally friendly, as if they are being conscious to climate change and all that, whereas in actual fact, they're not. That would be greenwashing in the basic sense. So climate litigation could also contribute to transformative environmental justice by promoting environmental justice. So climate justice does recognize that climate change disproportionately impacts vulnerable and marginalized communities, mostly due to their historical and systemic inequalities. So climate litigation can then be used to address these injustices by ensuring that climate action considers the needs and the rights of those most affected. So the decisions that our courts take should be sensitive to the vulnerabilities and the disproportionate impacts that marginalized communities face. So this includes demanding that climate policies should prioritize the protection of human rights, particularly the rights to a healthy environment, water, and food security, for example. Climate litigation could foster transformative change. It could act as a catalyst for broader societal change by raising awareness about climate issues, changing the dominant narratives, and promoting public participation in environmental decision making. So by centering justice in climate action, litigation can then help to ensure that climate solutions are not just effective in reducing emissions, but also contribute to a more just and equitable society. As I said at the beginning, that climate change litigation is most effective when it's combined with other strategies for addressing climate change. It is not a panacea to climate change. It is just one tool that should be used in conjunction with other tools to be most effective. So when used with other approaches, climate change litigation could create a powerful force for transformative change and ensure that climate change is both effective and equitable. And then these emerging trends that I just talked about, for example, the use of human rights in climate change litigation, they are also shaping the face of climate change litigation and making sure that climate change litigation is becoming a more powerful and evolving tool for advancing transformative environmental justice. And Section 2.4 of the NEMA, for example, provides that environmental justice must be pursued so that adverse environmental impacts, so this also includes climate change, that they are not distributed to unfairly discriminate against any person, particularly vulnerable and disadvantaged persons, because the impacts of climate change could perpetuate and magnify structural inequalities, for example, between women and men. So in South Africa, as with most parts of Africa, women rely on climate sensitive work like agriculture and manual labor to make a living. So with South Africa being a water stressed country, you find that women and girls mostly bear the brunt of fetching water and spend significant amounts of time hauling water from distant sources. This and also other climate-induced stresses could impact on their access to education and the labor market for women and girls by increasing the time that they spend on household chores, therefore perpetuating a cycle of disempowerment. So climate litigation should also consider this. If it is to be transformative, it should be very sensitive to these issues, and it could thus be used as a tool to advance environmental justice. Climate litigation also has its challenges and limitations, of course, and there are limitations and challenges associated with it generally, and then there are those which are associated with rights-based litigation specifically, but I'm not going to go through all that, but I'm just going to mention a few which are listed here, which is limited access, knowledge. Some people don't even have knowledge of climate change litigation. There is not much expertise in lawyers who are knowledgeable in this type of litigation. In some parts of Africa, for example, the costs involved, judicial conservatism, which with our judges, some of the judges from the countries that I was mentioning in the cases that I looked at, in some cases, in some countries, the judiciaries are not very welcome and comfortable with climate change litigation, especially when it uses environmental human rights. Although some have been active and we're getting there, but with some, there's still a lot of conservatism with regards to that, as well as the separation of powers, where some courts may not be comfortable in telling government what to do in terms of the remedies that may be sought by the petitioners in a climate change litigation case. So that's it from me. I'm going to hand over to Nesia to proceed and give to Tatenda. Thank you.
Thank you so much, Dr. Muzangaza, for a very insightful introduction to climate litigation. You went over your time for a bit, but I was really enjoying the presentation, and I'm sure our participants can also agree with me. It was quite informative. But moving on, we are now moving on to our next presenter, Ms. Tatenda Muponde. She'll be bringing a practical perspective to climate litigation in South Africa. Ms. Muponde, you have the floor.
Thanks, Nesia. Can I just please share my screen?
All right, sure. Let me stop sharing.
Thank you. Can everyone see my screen?
Yes, we can see your screen.
Okay. Yeah, thank you very much, Dr. Wendy, for just that nice layout and setting the basis for this presentation. I really enjoyed your presentation and was looking forward to hearing more on some of the things we're talking about. But yeah, like what Nesia said, I'm just going to be bringing in a more practical overview of climate litigation in South Africa, particularly based on the work that we are doing at the Center for Environmental Rights. And so for this presentation, I'm just going to briefly touch on what climate litigation is, but we already had an extensive presentation on that. And then just going to some of the case studies in South Africa. I'm going to specifically focus on 3 cases that the Center for Environmental Rights brought, which would be the Thabameti case and the Council Coal case and the Deadly Air case. Then I'm just going to go into what has worked so far, what's still missing, and some of opportunities for future litigation when it comes to climate litigation. So as Dr. Wendy mentioned, climate litigation is a growing tool in Africa, globally, and as well as in South Africa. And what makes South Africa quite great is that the legal system itself provides fertile ground for climate litigation. And this is particularly because of the constitution that we have and some strong environmental laws that sort of help with bringing in that litigation. An advantage South Africa also has is an active civil society, which is playing a key role in bringing climate litigation cases. And this is also coming from like a historical perspective where apartheid actually capacitated and empowered people to do something like that. So we're just like continuing with like movement lawyering, and it's quite helping. And the kind of litigation that we're seeing is litigation that's targeted against government's failure to act or corporations, pollution or emissions. And then there's also some that are supporting community rights. And also it is still heavily based on rights, which are rooted in the South African Constitution. And there are at least 11 cases in South Africa that are classified as climate litigation cases. 9 of them have been successful, and 2 are currently pending on appeal, right? So we are making headway in terms of bringing climate litigation in South Africa.
Tatenda, just a moment. Sorry to interrupt.
Okay.
Yes, I don't know if you can put your presentation on presenter mode. Yes, great. Thank you. Yeah.
Right, and now I'm not sure where it was. Here. And I just changed it. There we go. Yeah, so with climate litigation in South Africa, the Southern Center for Climate Change Law defines climate litigation as cases that are brought before judicial bodies in which climate change law, policy, or science cases where they might not specifically be dealing with climate change law or policy itself, but they do have an impact in terms of climate mitigation or adaptation. And therefore, we might want to be considering like what is actually climate litigation and be thinking about expanding that definition. And even from an African context, like what does that mean? Because a lot of the cases that are being brought globally are focusing on climate mitigation, whereas from the Global South perspective, we might be seeing a lot of climate adaptation cases having to be brought. So where does what fit? So yeah, I do agree with Dr. Wendy on that, that we might actually need our own Global South perspective on what is climate litigation. And then in South Africa, climate litigation so far has been largely rooted in administrative law. And this is because we do have a constitution that sort of entrenches administrative law in terms of Section 33, and it's also in our legislation in PAJA. It's a well understood legal route, and it's quite neutral, right? So it has really helped in terms of like bringing climate litigation, and we've had some exciting successes in some of the cases that we have. However, the disadvantage of this route would be an over-reliance on procedure, which I think is quite a universal disadvantage when it comes to environmental justice cases in general, where because of how they are brought, they tend to be more procedural than substantive. So that's just something where when you're thinking of climate litigation in future, what the gaps are and what we need to enhance, just to think about not just focusing on procedure, but also how to enhance substantive rights, but also the jurisprudence of, say, Section 24 of the Constitution and other legislation. Yeah, so with that being said, I'm just going to go into some of the cases that we brought. So the first case that we have is the Thabamesi case. So this was a challenge to a proposed coal-fired power station in South Africa, which was around 2016, 2017. And it was grounded in climate change impacts and procedural injustice, right? And basically in this case, this is where the courts basically said that we need a climate change impact assessment in any in environmental impact assessment processes. And the project was ultimately abandoned, right? So basically, this is the first climate change case in South Africa which set legal precedent on climate considerations in environmental approvals. And what was quite interesting about this case is that much as there was a legal process going on in the courts, much of its success, I would think, rested outside of the courts than it did in the courts, so much as we do have this legal precedent that now says we need climate change impact assessments stated in EIAs. There was also like other approaches that were used which happened outside of the courtroom. So the first thing that happened was there was a modeling that was done by experts showing just how expensive this project would be if we were to proceed with it in South Africa. And that modeling was then used to advocate against this project, right? So they used it to approach banks, for example, who were like the financiers of the project, to actually say, this is the project you are funding, these are the impacts that it's going to have. Do you really want to be funding something that is detrimental to our future? And and there was a lot of shareholder activism as well that was happening. NGOs also just like engaging the boards and banks as well. And eventually the banks who were financing this project, this is Thabamesi as well as Kanisa, they put out of the project. And obviously if there's no money, the projects cannot go on. So much of the victory in this particular case is also owed to these alternative approaches that were used outside of the court. Then the second case would be the Deadly Air case. So this was brought by Groundwork and Vukani Environmental Movement against the South African government. So this is a case that arose from decades of like advocacy in the Mpumalanga Highveld, where it is one of the most polluted regions in the world, and they've been calling for the protection of this area, and eventually it was declared a high-level priority area. And in terms of our law, once an area is declared as a high-level priority area, you have to implement an air quality management plan for that area. And in terms of that, you also have to, the minister has to implement regulations to sort of show how the air quality will be managed in those regions. So what then happened is, after it had been declared, it took another 4 years or so for the minister to actually then come up with an air quality management plan. And then after they implemented it, it took another 10 years before they put together regulations on how this air quality management plan would be implemented in the high volt. So what started as advocacy then ended up in court, where the applicants were basically trying to force the government to prescribe regulations to enforce this high-level priority area air quality management. And they argued that the delay was unreasonable and a violation of Section 24 of the Constitution. They also sought a declaratory order, which basically say that toxic air pollution in the high-level priority area was a direct infringement of the constitutional rights to a healthy environment. And as a result of that, the court actually declared the poor air quality in the HPA as a breach of constitutional rights. It also stated that environmental rights are immediately realizable, which means that they are not the same as other socioeconomic rights where you can progressively realize them. They have to be realized here and now today. And then the minister was also and then the court also said that the minister must prescribe and implement regulations to enforce the air quality management plan, because you can't enforce the plan without regulations that tell you how you're going to go about that. So this is essentially the first South African case recognizing air pollution as a constitutional rights violation. With deadly air, though, with deadly air as well, there was the litigation that was happening in court, but like I mentioned earlier, it came out of decades of advocacy, which firstly led to the declaration of this high-level priority area. But during the litigation process itself, a lot of expert reports were commissioned by the applicants to sort of like amplify and supplement the legal arguments, but also to be used in advocacy. They also used the government's own reports that were showing that hundreds of people were dying in the Mpumalanga High Veld as a result of this toxic air pollution. There was strong client-led advocacy campaigns as well, and a lot of media coverage on the case. And another thing that helped with this case was the amici interventions from the UN Special Rapporteur on Environment, David Boyd, who came in to talk about the right to a clean environment, and then also the Center for Child Law coming in to connect the environment to the rights of the child. There were also like a lot of advocacy around community voices actually highlighting impacts. So this was in and outside of the court, right? So the court papers were, there were actually affidavits from communities actually saying, this is my lived realities and this is why you have to do something. So it was like a combination as well of the litigation, but other approaches that were being used outside of courts that sort of helped to not just raise the awareness of the issue, but to also substantiate and strengthen the case. And I just want to say on deadly air, generally, if we're going back to the definition of climate litigation, it wouldn't necessarily fit in because it was more of an air pollution case than a climate litigation case. But given the fact that reduction of air pollution actually leads to mitigation of like emissions and climate change, then I would think it also should be considered as a climate litigation case rather than just a pollution case. The last case I want to touch on is the most recent one, which was brought by, which was our first youth-led climate litigation case in South Africa, brought by the African Climate Alliance, Groundwork, and Bokani Environmental Movement. And this is the case that challenged the government's energy plans to build new coal-fired power stations in South Africa. And they essentially argued that the IRP contradicts climate commitments under the Paris Agreement and South Africa's constitutional obligations. And it's sort of significant because it tried to also bring about arguments on intergenerational justice and climate ambition and accountability. And much like Deadly A as well, what's worked in this case was a very strong client-led advocacy campaign. It was youth-led, so there was like a lot of interaction with young people, like raising awareness on why canceling coal is an important thing, why climate change is an issue we should be addressing in South Africa, and why this energy plan is not saving us for the future. There was a lot of media coverage. And also there was expert research commissions, which also sort of had an interdisciplinary approach where we had to bring even psychologists to come and look at the mental health impacts of climate change on youth, as part of bringing this case. There were also amicus interventions that also helped, particularly the ones that focused on the rights of the child. So essentially, when it comes to the climate litigation that we're seeing that it's not just one tool that's working. It's almost like a mixture of different approaches that are being used as you bring about the litigation that is leading to more success and victory. And victory is not just in the courts, it's also outside, because sometimes you can get a judgment, but if nobody else outside of the courtroom can sort of like understand what you're doing or why you were doing it, then sometimes it might not have the impact that you wanted to have, or empower others to also, advocate for their rights and so forth. So just that mixture of approaches has been helping. There is a strong legal culture of public interest litigation in South Africa. So a lot of movement lawyers are leading climate litigation in South Africa and just bringing those strategies that they've sort of cultivated over the years when it comes to public interest litigation and trying it out in climate litigation cases. A lot of the cases have been strongly talking about the justiciable Bill of Rights that we have. And also with our courts, they are quite open to international and foreign law, which is quite helping in the interpretation of the rights and how they are dealing with some of the issues coming out in these cases. So that's working in our favor in South Africa. And then the amici interventions have also been helpful in litigation processes because they help to address some blind spots. They're also helping to provide scientific basis for arguments where you may be lacking, and also introducing new concepts, right? Which has been quite essential, especially when it comes to helping the judges to really understand climate change and environment in general, because it can be too technical and abstract. And then robust advocacy campaigns have helped not just the litigation itself, but in actually raising public awareness on climate change and environment, and sort of pushing the agenda of environmental justice in South Africa. What's currently missing right now is we're seeing a lot of cases around mitigation, but I don't think there has been any case on climate adaptation in South Africa. So that's like a gap, and it's quite an essential gap, because when you're thinking of South Africa and our history and, just basically the fact that South Africa is an environmentally unjust society and vulnerable to climate impacts, climate adaptation cases are going to be very important in the near future to sort of try to remedy what's currently going on. What's also missing are climate litigation cases that are promoting more of a restorative justice agenda. So we are seeing legal victories that are not translating to real world change. So here I'll give an example of Deadly Air, for example. So we have this beautiful judgment that's basically saying, yes, toxic air pollution is a violation of your constitutional right to a healthy environment, and we recognize that. But when it comes to how is it actually helping people on the ground in the Mpumalanga Highveld, it hasn't really changed their lives much. So it's like they're holding a piece of paper, but their lives haven't changed. They're still breathing toxic pollution. They're still not having access to good health. People are still dying. So there wasn't like an approach around, yes, procedurally something was wrong by the minister not prescribing regulations, but how do we also change the lives of the people who are through this in the process of bringing this litigation? So that's something that's currently missing in our climate litigations cases so far. And marginalized communities are still bearing the brunt of proving are still bearing the brunt of the harm, and also burden of proof in courts is still lying on them. So we're having a case where rights are existing on paper, but the implementation is fragmented or non-existent. And when it comes to environmental justice, it's actually a realization that real transformation happens when when procedural justice is coupled with distributive and restorative justice as well. So in terms of opportunities, there's definitely an opportunity for future challenges to coal-fired power, but also other fossil fuels, right? So currently we are sitting, a lot of the cases that are coming are around new coal-fired power stations, but we're also sitting with about 15 or 16 power stations in South Africa that are in existence, right? And there is an opportunity for other litigation to come through that, maybe via decommissioning cases or something. But then also oil and gas is being seen as a transition fuel right now, and we are going to see a surge of cases coming as a result of that. There's also an opportunity for loss and damage claim, just sort of trying to redress what I was talking about earlier, where we're getting judgments, but they're not really changing much the lives of the people or addressing the harms that are being suffered. And I think South Africa is quite ripe for a loss and damage claim case right now. There hasn't been one, as far as I know, on the African continent as a whole. And South African law does provide broad grounds of standing, which can include things like class actions, which make it ripe for such a case. And there's also some funding available on loss and damage cases as well. And even legally, there is a support for contingency fees, which can help with bringing some of the cases, because then you don't have to be paying upfront. And also this situation is also providing an opportunity to develop our common law in South Africa, which is something that the Constitution also mandates our courts to do, particularly when it comes to developing the law of delict, right? Because it's going to be one of the key laws to use when we're bringing loss and damage claims in South Africa. And then there's also corporate accountability, where a lot of the cases right now have been focusing on state accountability, but in future, there is the potential where we're going to be seeing companies actually being sued for pollution and emission because as bearers of constitutional rights, because our law, including our environmental legislative framework, actually allows for this, particularly when it comes to like polluter pays principles, right? There's also a new, I don't want to say new, it's not as new, but then another mechanism that is being used on holding people accountable, which is shareholder activism. So sometimes it might be, so in terms of our Companies Act, 2 or more shareholders can propose resolutions for any matter. And currently, some NGOs have been actively proposing climate change resolutions at AGMs and so forth. But what companies have now been doing has been to try and block the participation of those shareholders in their AGMs, and sort of like try to make sure that those kind of resolutions don't come. And so another form of litigation that could be coming out in relation to climate change would then be around this shareholder activism and the limitations to participation. And then the last thing would, that's another trend that's coming, is the use of regulatory bodies. So going to court is quite expensive and can be a very long process, right? So people are now starting to explore other mechanisms and other bodies that are available to litigate and hold polluters accountable. So, for example, in the fossil fuel-free South Africa versus Total Energies case, this is the first greenwashing case in South Africa, and they didn't use the traditional legal route of going to courts, but rather they approached the advertising regulatory body of South Africa, which is charged with the mandate to safeguard the environment and climate change. And what had happened in this case was that Total had partnered with Sanbi, and as part of their partnership, partnership, they were advertising themselves as a company that promotes sustainable development, which is quite contrary to what they do because they are predominantly a fossil fuel company, right? So it's sustainable development is not like a primary core business for them. So Fossil Fuel Free SA argued that this was greenwashing because they were making false sustainability claims. They won on those grounds, and it sort of like changed perspective because then it opened up other avenues that you can bring this kind of litigation outside of our traditional courts, right? And it also led to the advertising regulatory body itself developing policy to deal with climate change and greenwashing. And basically what then this shows is that we're going to be seeing a surge of climate change cases that may also be coming from either other different statutes in South Africa, especially when it comes to greenwashing. It can be coming from the Consumer Protection Act and so forth, and not just the traditional constitution. And I think that's an opportunity that we have. So just in conclusion, just to say that there is a rise in climate litigation and opportunities for more cases to be brought outside of the general mitigation cases and state accountability cases. And also just to belabor the point that Dr. Wendy was saying, that climate litigation, as with strategic litigation in general, is just a tool to advance environmental and climate justice, but it's not the only tool. It's complementary to other approaches such as activism, campaigns, and awareness raising. And together they create the change that we want to see. So definitely multiple strategies are required. And we can use litigation, and litigation can be used as just like a stick, to push things forward and develop the law, but it's not the only solution. And another key thing is climate litigation is bringing collaborative thinking from different disciplines. We're seeing an intersection of science and law, of health, also being brought forth in these cases, which is sort of helping to enhance and also sort of show the interlinkages of environment and every other aspect of our society. Yeah, and just in the spirit of climate litigation and climate change, and how we've also realized that to create impact, raising awareness on environment and climate education is quite important. What the Center for Environmental Rights is also doing is to develop an environmental and climate change education advocacy tool that we are calling Ask Karabo. We are launching this next month, and it will be the intersection between communities, youth, and children, where we'll be basically capacitating and empowering communities, youth, and children on the environmental and climate change rights and how they can enforce them, which is an essential tool when we're thinking of litigation in the future, but in basically trying to build a just and sustainable future for all. So I'm going to pause now and hand it here. Thank you very much.
Thank you very much, Tatenda, for that insightful presentation. I think one of my key takeaways from this presentation, it was just to show the key strengths of right-based climate litigation, and that it lies not only in securing favorable court outcomes, but also in its broader advocacy impact, and how these cases can play a powerful role in raising public awareness and holding both the state and private actors accountable. So even if a case doesn't succeed in court, the litigation process itself can build momentum for policy change. Yeah, wow, that was quite interesting and insightful. And I'm sure, as we can see, as we will tell, we are now getting into our Q&A session, and I am pretty sure our participants are bursting with questions right now or comments to contribute to the conversation. So I will invite Ms. Innocentia Mahlangu to come and facilitate the Q&A session. Thank you.
Thank you, Nesia, for the introduction. Well, I am Innocentia Mahlangu from here at CLES, a LLM researcher. Firstly, I would like to thank both of our presenters, Dr. Muzangaza and Ms. Muponde, for a meaningful presentation on climate litigation, which is a predominant and emerging topic. I hope we all enjoyed it. It was particularly exciting for me, especially since my research is based on climate mitigation. Well, the rules for this Q&A are simple. We will have several rounds of questions with 3 questions per round. So please, if you have any questions, feel free to raise your hand or post them in the chat box. You can specify which speaker your question is directed to, or just post the question. Our speakers will decide who answers or whether to join efforts in answering. Well, as the person with the microphone now, I will take the advantage and ask the first question. Well, the last speaker touched on this, so it's mostly a clarity-seeking question. Well, climate change litigation is often seen as focusing on holding government and the private sector responsible for their failure to implement effective policies to combat climate change. My question is whether such lawsuits can effectively tackle the direct impacts of climate change that people experience, such as flooding that destroys homes or droughts that ruin crops. Like, is there a clear connection between these damages and the negligence on the government's part? Or could these events be regarded as beyond human control? Basically, how far can individuals go in holding government accountable for the harm caused by climate change? And that is my question. So for now, I will take the first round of questions, which will be 2 questions, and then we will give our speakers the chance to answer, and then we'll move to the second round of questions. Any questions?
Please, a hand on.
Okay, if there is a hand, Victor, you can pose your question.
All right. Good afternoon. My name is Victor Ayodele. I am an LLM researcher. So it's not basically more of a question, more of like a comment, basically. And this is addressed to Dr. Wendy. You talked about Nigeria. It was mentioned a couple of times, I think like 3 times, Serap versus the president of Nigeria, Serap versus Shell. What my comment is, and you stated that there is conversationalism as regards the judiciary. So what I want you to understand is, in South Africa, the Constitution basically provides for the Bill of Rights, and I believe maybe in section 3, I'm not quite sure, but there is the right to good life, to water. But as opposed to the Nigerian, I want you to understand this, that the reason why it is that way in Nigeria is because there are 2 sections for rights in the Nigerian Constitution. There is the fundamental human rights from section 33 to I think section 45, which is justiciable. And then there is the fundamental objectives and directives of state policy. Now, this particular fundamental objective is something that the Nigerian government is supposed to strive towards to achieve. However, that particular section, that particular chapter, which is chapter 2 of the Nigerian Constitution of the Federal Republic of Nigeria, 1999, as amended, is not justiciable. It is not justiciable in the sense that you cannot sue the government to court. And if you cannot sue the government to court, that means they do not have, there is no legal backing, there is no legal punishment. You cannot punish them for not bringing such rights to existence. So what I'm saying is, it is as a result of the law. What would have to happen for that particular climate change issues to be solved is that that particular side of the Constitution, that chapter 2, must be justiciable, has to be justiciable. But that won't happen because the Constitution of the Federal Republic of Nigeria is rigid. And for them to do that, it will take a very long process. And this is the reason why most of these cases you've said, Sarah versus President of Nigeria, you said it, right? You said the government, the court said the government failed, but there was no punishment for the government. There was because it's not justiciable, you cannot punish the government for not doing it. It just said that yes, the government was wrong, but it's now up to the government to actually implement that, and they will not do that because the government benefits from oil. Basically, even the president of Nigeria is in charge of oil-related matters. So what I'm saying is there's a deadlock, there's a chain that strings the courts from actually doing something meaningful. And the way Nigeria's legal system is structured, it is structured in a way that the courts cannot deviate from what the law says. And if the Constitution says you cannot punish the government, there's nothing the courts can do. So that is my particular comment about what Dr. Wendy said.
Thank you for the comment, Vita. Hopefully, Dr. Wendy will answer to that. And then there is a question from Mr. Brian Sizani in the chat box directed to Dr. Muzangaza. Dr. Muzangaza, in her introduction, mentioned that climate litigation is more prevalent in the global north, and the drive to do likewise in the southern parts is being pushed for. However, during the industrialization age, when the global north developed their economies, they had no litigations. Now that they are developed countries, they have disposable income to develop clean solutions, for example, nuclear energy. As in the Tabamiti case presented by Ms. Muponde, climate litigation can indeed deny Africa fundamental technologies like coal-fired power plants, which may be low-hanging fruits that can be harnessed by Africa for its own development. So the question is, are there any legal frameworks or policies in place that will ensure Africa develops their economies and cities using cheaper and affordable technologies, although those technologies are not best for the climate, so as to afford Africa a fair chance of self-development? Well, we will now give our speakers a chance to answer. First, it will be Ms. Muponde with the question that I posed. That will be followed by Dr. Wendy to address Victor's comments and the question just asked. Thank you.
Thank you, Innocentia. The question you posed is it's a tricky question that we are also trying to sort of like navigate, right? In terms of how do we bring about cases that address like those environmental harms? I mean, if you're looking at the KZN floods, for example, what kind of a case could you bring to actually address the environmental harms suffered there? And can you link it to climate change, or is it just like a natural disaster? And some of the things that we are sort of tackling with or having challenges around are about the burden of proof, right? So thinking of things like causation, how do you link what happened to, say, a particular polluter? How do you link it to the state, and how do you hold them accountable? And there's been conversations around using attribution science, for example, to try and improve causation, but I guess it's still a challenge and it's still an area for us to explore. But I think there's definitely potential to see how we can bring about those cases. It's just a matter of what would that look like, and how would you phrase it, and what else would you need to support that particular case. But it's definitely an area to explore.
Thank you for that answer. Hopefully there will be developments in that area, and we're still gonna see more cases. And now I'm off to Dr. Muzangaza to answer her questions. Thank you.
Thank you, and thank you to the people who have posed the questions. I want to start with Victor. I do understand, and I am aware that Nigeria, for example, does not have an explicit right to a healthy environment, but it does incorporate the environmental right in Article 24 of the Banjul Charter in their law by including that right in the African Charter on Human and People's Rights Procedure Rules, which is their ratification and enforcement, the Procedure Rules Act, which is I think the act that I'm not sure if you mentioned it, but yeah, the Act of 2004. So, like what happened in the Bama case, though they did not, though that part of the Constitution is not justiciable, as you said, the court was actually very innovative in deriving the right to life from the right to a healthy environment, which is provided for in the Banjul Charter, which is then included in Nigerian law. So that way, and also another advantage of then using environmental human rights, as I was saying, is they are indivisible, and you can derive one right from the other right, just as the court did in that case. Thank you. I did not hear the second question, Innocentia. If possible, could it be typed in the chat box, perhaps?
Yes. Oh, yes, it's already in the chat box.
Okay, let me go there. Thank
I
you.
will give you a moment to go through it and read. I will read the questions that are posed in the chat for our speakers for now. Okay, we have a.
Excuse me.
Yes.
I think that we should allow Dr. Wendy time to read that question and then respond to it. Because if you are reading other questions that are directed to her, while she's trying to read and understand that one, she will probably lose it, not be able to grasp it.
Yes.
And then we can also urge participants to try and keep their questions direct to the point instead of having a whole paragraph to ask a question.
Okay, we will allow Dr. Wendy to go through the question and answer, and to take Prof's points, can you please keep the questions brief to allow our speakers to answer, and also take note of time when we are asking questions. Thank you.
Created conditions that violated the right of access to, the right to life and the other rights that are related to the right to life. So the case centered on the right to life, not directly on the environment. And it's an interesting judgment, which if you have time, you can read. And you also come to realize that even if you deal with rights that are directly protected in constitutions, and then the adjudication taking place at international or African regional level, we always have the perennial problem of enforcement of international law, where even if the United Nations or the African Commission or the International Criminal Court rules for the particular matter against the state, in the absence of pressure from other states, at times it becomes almost impossible to enforce it. So the enforcement is not really limited to the fact that the right is not expressly guaranteed in a constitution or legislation of the country.
Yeah, thank you, Prof, for that. Dr. Wendy just indicated that she will answer in the chat box. So we can now move to the second round of questions. If you have questions, please raise your hand or type in the chat box. We already have questions from Mr. Moinate in the chat box directed to both speakers. Well, the first one is, what alternatives to climate litigation can be most effective in supporting poor communities that lack access to financial resources and legal representation? And then the second question is, what role can municipalities being closer to the people play in addressing climate impacts on poor communities, and how can they be empowered to develop and implement effective climate adaptation and mitigation strategies that meet the specific needs of communities? And we have another hand from Victor.
Is it an old one or is it a new one?
You can pose a question.
Okay. All right. Good evening once again. My question, not question, basically, just also a comment as well. It's not directed to anyone, it's just directed to the two speakers. Probably they can shed light on it. My comment is basically on not only the fact that climate change is caused by corporations. Climate change challenges are caused by corporations. It's also caused by individuals, in the sense that I would just state capitalism, then I will come to how capitalism in turn causes climate change challenges. So basically, everyone uses cars, and also not only is that they are cars, they are also animals in which we as humans use for sustenance. Now, what I want to state is that the smoke produced from cars and also the dung produced from specifically cows contains something called methane and benzene. So methane and benzene usually would not be harmful if there are enough trees to disperse these particular chemicals. But however, there is large deforestation due to the fact that there is increased population, and that's where I would like to state something else. That will be for another question later. But other than that, those two chemicals, for example, if you can go around to search, you would see that there is a particular how do I put it? There is something it causes to the environment which depletes the I think UV rays, basically. I don't know how to explain it because I'm not, it's time. Sorry. Yeah, so what I was trying to say about capitalism is that there are technologies in which we can use to take this out of the way. For example, cars, the use of cars, by using electronic vehicles and then solar-powered vehicles, which is very expensive. And for you to be able to say that we want to take this away, there are corporations that will not allow that, because there are people who have come up with this particular type of devices to use to substitute the use of gas, which destroys the environment. But we find out that most of them die before they could finish their inventions. So that's what I wanted to say. Capitalism also contributes to climate change challenges because of the greed of human beings, which does not allow the planet to thrive. So that's what I would say.
Thank you, Victor, for the long comment. As I said, can you please try to keep it brief? Well, I will open the floor to our speakers to answer. Seeing that Dr. Wendy said that she's going to answer from the chat box from now, I will give the opportunity to Ms. Muponde to answer to the questions. Thank you.
Thank you, and thank you everyone for the questions and your comments as well. So just to touch on the most recent question, I think was Victor just talking now, just a brief comment there. I think when it comes to capitalism and climate change, it is true that overconsumption and overproduction and what capitalism stands for, the constant need for growth is actually exacerbating climate change, right? And when it comes to a just transition, it's quite impossible to be able to achieve a truly just transition and really satisfy the concept of justice based on a capitalist model, right? So then it has become quite critical in terms of climate mitigation and adaptation to think of alternative economic models that we should also be transitioning to in order to support that just transition. And capitalism may not be the best because of how it's based on growth, on like a needless, on this need for growth. So what kind of other economic models should we also be thinking about in this transition in order to address these challenges we're currently facing? And then just to go to the other question in the chat box on other alternative mechanisms to climate change litigation. I think it is true that litigation can be very expensive and costly, right? But I do think what's kind of available right now can be advocacy, right? And we've seen how advocacy has really worked in sort of like trying to stop some of the development projects that have that had detrimental impacts on climate. So, for example, with Tabametsi, right, the nub of that victory was really about what happened outside of court rather than what actually happened in court. So advocacy does help a lot in pressuring governments and corporates in changing behavior and in just like altering their decisions, right? And this is essentially why at the Center for Environmental Rights, we do have the activist support and training program, because it's there to capacitate and empower communities with their rights and information on how they can then challenge and put pressure on governments and on polluters without necessarily approaching the courts and using the courts maybe as a measure of last resort. And this usually happens, say, even at the beginning of EIA processes. If people are capacitated with the right information, if they know that the mechanisms are available to them to enforce their rights, they can be in a position to actually stop certain things from happening before they've started to harm them, right? And this is also why we are also introducing like Ask Karabo, because it's there to capacitate communities and children and youth to say, you have this right and this is how you can use it to start putting pressure now, because education and awareness raising is very important and it can actually stop some of these things before they've progressed to a point of causing massive harm to people. And then our other avenues that are available, I mean, Fossil Fuel Free South Africa has showed how regulatory bodies outside of courts can also be used, right, to advance climate change issues. And these are usually less costly than going through the traditional legal route. So that's also available mechanisms that communities can use. Another potential area to explore when it comes to climate change issues and advancing climate justice could be alternative dispute resolution mechanisms. So such as mediation, instead of taking each other to court, can we sit down and sort of try and come up with a solution that works and that sort of promotes, and upholds people's rights in the process. So that's also a potential avenue to explore, apart from just like going to court, which can be resource extensive, right? And then just briefly on the role of municipalities, I would say municipalities are on the front lines for climate mitigation and adaptation. I mean, they do the most with local communities, and therefore they do play quite a critical role in climate, especially in climate adaptation. So with the Climate Change Act in South Africa right now, you see that there is actually a specific provision where they make provisions for municipalities to actually show that you have a critical role to play when it comes to addressing climate change issues in South Africa. And this can be in terms of developing local climate change response strategies, and integrating climate risks into their integrated development plans or into their special development frameworks, because these are things that they use, right, every day in their duties and obligations, right? And even in like basic service delivery, I mean, think of issues around waste. Waste has huge climate change impacts, and if they were to just like address a waste issue, like just that could also help communities a lot. So they do play a critical role. And however, the issue currently right now, I just had a meeting with one of the municipalities last week, and they were talking about how they are strained for capacity. You'd find that maybe there's only one person dealing with an environmental issue or climate change in one municipality, and that person is probably sitting at the, at the district municipality, and they're responsible for other 20-something towns, right? And so they're quite stretched for capacity. So as we're trying to deal with climate change in South Africa, one of the things we actually have to do is to then really capacitate and empower our municipalities to be able to handle this responsibility and obligation. Yeah, thank you.
Thank you for that. Anyone who has a question can read my research once it's published, because I'm also writing basically on what Ms. Muponde just touched on, the role of municipalities, how they can be empowered and so on. Thank you so much for that insight. And now we're gonna move to the third round of our questions. Firstly, I'm going to give Ms. Manguleni an opportunity to ask the question, and then we're going to read from the chat box. Thank you.
Thank you so much, Innocentia. I think, Ms. Muponde, you briefly touched on this, but I just wanted to ask, civil society organizations such as the Center for Environmental Rights are playing quite a pivotal role in bridging the gap between legal rights and the lived realities of communities affected by various environmental harms. So to what extent do you work collaboratively with local government structures to ensure that legal victories translate to meaningful changes on the ground?
For that question, and then we have a question from Prof. Fuo. Does the framing environmental rights and the rights of nature make any difference in the push for and outcomes of climate change litigation? And then we also have another question from Dr. Lawrence directed to both speakers. Has causation ever been proven in any case before a court in the context of climate change, locally or international? Seeing that Dr. Wendy is still answering to, or in the chat box, we're gonna give Ms. Tatenda an opportunity to answer the questions. Thank you.
Yeah, I'm just going to answer the question on the extent to which we're working with local government structures. I think sometimes it's quite difficult because politics does play quite a role, and chat can be like a stumbling block in trying to work with state entities. But then what we try to do is to sort of like engage with them and sort of like hold these meetings and platforms where we are saying we are all fighting for the same thing, we are on the same side, can we talk? And I did mention a meeting with one of the municipalities recently. It was really just to say, this is how people are being affected in your community. How can they engage better? How can we work together to ensure that these rights, their rights are not constantly being infringed, right? So it's a constant battle of trying to really open up these platforms, but also being cognizant of the fact that sometimes it might work, sometimes it might not. And then you have to sort of devise new strategies, but it's something that we're constantly striving to try and do as well.
Thank you, Ms. Tatenda. Hopefully, Dr. Wendy is going to address the other questions in the chat box, and then this moves us to another round of questions. If there are any hands, please raise them. For now, I'm just going to go through the chat.
Excuse me.
Please.
Hi, Tatenda. Given that you are the only one who is able to respond orally to the questions that are posed, I feel like we may overwhelm you with questions. Are you prepared to take a few more?
Maybe I can take one or two more.
Okay,
I'm just not sure of some of the other questions in the chat box, so I thought maybe Dr. Wendy could assist with that. Yeah.
Yeah. So if you have specific questions directed to her, you can ask them at most two. And then if Dr. Wendy is not there to respond, we can move to the next part of the program.
Yes, so I'm gonna read the questions in the chat, and Ms. Muponde, you can choose which one you're gonna respond to. So the first one is from Tato. Do you consider scientific complexity to be a significant challenge in climate mitigation aimed at advancing climate justice, particularly given that marginalized communities or the organizations representing them must establish a prima facie case, while the judiciary is tasked in interpreting technical data and interdisciplinary evidence? And then the second question is from Ms. Robertson, directed to both speakers. Firstly, thank you for the presentation. Well, the three pillars of sustainability, social, economic, and environmental, are constantly in conflict with each other. There is a constant trade-off between the pillars, and the environmental pillar is frequently overshadowed by the other two pillars. Is there space in the relevant law and policy for means to start prioritizing the environmental pillar above the two? And do you foresee this being a viable option? Well, seeing that we don't have any other question. Oh, there is a question from Victor. Victor, can you please keep it short?
Okay. All right. So basically, I've not really even asked the question today. I'm just going to just give suggestions, basically, or comments. What I would be suggesting because what we have is a problem with implementation and a problem with punishment of people who break environmental laws and climate change laws. So what I would suggest is that there are more stricter punishments, because the only punishments that we know of are monetary punishments or compensatory punishments, where the court will tell the companies to go and compensate the people affected or to pay some fine. And that's the only thing. But what I would be suggesting is that there are stricter punishments, for example, lockdowns on particular companies, because what you understand is that there's something called glass flaring. So glass flaring, it is easier to flare gas than to actually take and what's it called? It's not only easier, it is also more cost effective to flare gas than to actually take cautions not to flare gas. So what I would suggest is that there should be stricter punishments, lockdowns, arrest and prosecution of people who break laws, because we are dealing with lives, people who die as a result of this glass flaring. So there should be changes in laws to effect stricter punishments, strict liability offenses, and as well as vicarious liability offenses, where the whole company should be punished and should be strictly punished for some of these offenses created. So that's nice.
Thank you, Victor. Thank you, Victor, for that suggestion. Well, we're gonna give Ms. Muponde to answer to those questions. Not all of them. She's gonna pick which one she's gonna answer, and then the others are gonna addressed by Dr. Wendy in the chat. Feel free to reach out to her also. Ms. Muponde, the floor is yours.
Thank you. So just briefly on the scientific complexity, it is true, because a lot of the cases, it's not just the science, but it's also because the documents are too much, and sometimes courts are overwhelmed, right? So even judges may not have the capacity to just like go through everything, but also because this is like quite new, the complexities just presents another layer of difficulty. But I think an opportunity there is that, for example, with amicus, right, they can actually come in to explain the complexities. And another thing that has worked in some of our litigation, for example, with deadly air, was breaking down the signs for the judge, right, to actually say, this is what we essentially mean in simple terms. And that kind of helps and sort of removes that challenge, but it still remains a challenge in explaining climate change when it's so scientific. And then when it comes to the question on sustainable development, I'll be a little bit weary to prioritize the environmental pillar above the other two. And this is essentially because much as development cannot subsist on a deteriorating environment, we also can't separate people and their needs from the environment. And if we're just going to be focusing on prioritizing the environment, we run the risk of just protecting the environment for its own sake and forgetting that there are human lives that are also heavily impacted. And, we also do have development needs, and we also do have poverty and unemployment that we need to consider in these processes. So you can't just be protecting environment for the sake of protecting it. We also really do need to address other social injustices and that we are currently facing, right? So I would still say, much as we can, let's try to amplify the balancing act of these three pillars instead of trying to elevate the one over the other. Just everybody getting to a point of understanding that it is a balance. All of them are as equally important, and one should not be elevated above the other.
Thank you, Ms. Muponde. That was the last round of our questions. Thank you for the burning questions, everyone. You made the rounds run smoothly. Well, if you still have burning questions, you can email them to Ms. Nesia. She's gonna forward them to our speakers, and we're gonna get your answer. Thank you so much for participating.
Thank you, Ms. Mahlangu, for facilitating our Q&A session. We're now moving into the next part of the program, which will be final inputs from our speakers. I don't know, Ms. Muponde, do you have any final inputs, or you have exhausted your final inputs even on answering all these questions?
I think I've exhausted it. Yeah, I'll pass it on to Dr. Wendy.
All right. Thank you so much for your participation and for keeping the conversation interesting and engaging. I will now hand over to Ms. Ledile Sekwakwa to wrap up the event for us.
All right. Hi, everyone, or good afternoon, everyone. As Nesia has already mentioned, I am Ledile. I would like to firstly thank our speakers, Ms. Tatenda and Dr. Wendy, for their very thorough presentations and enlightening insights on climate litigation as a tool for transformative environmental justice in South Africa. I really think we all learned a lot, and some very interesting insights were brought to light today. And I also believe that today's discussions reminded us that climate change litigation is not merely a legal strategy, but rather a powerful tool for challenging systemic injustice, demanding accountability, and also in amplifying the voices of those most affected by environmental harm. So I anticipate that this discussion will not only end here. So thank you, Ms. Tatenda and Dr. Wendy again. It is much appreciated. Thank you, Nesia and the Critical Conversation team for organizing this beautiful event. And thank you, Ino, for such a beautiful work, for facilitating the Q&A session. We appreciate it so much. And also thank you to the audience. Thank you for joining in, for participating, as well as for asking such very valuable questions. We also appreciate you. Make sure to keep an eye for an invitation for our last critical conversation later this year. And also feel free to follow CLES on our various social media platforms. And thank you so much. Thank you very much. See you again soon. Bye.
Bye, everyone.
Thank you, everyone. Bye.
Thank you so much, everyone. Bye. Until next time.
Thank you. Bye.